perfect it. And who's to know if it's perfect yet? Because it may fit in some cases and it may not solve them all. Anyway, that's my remark. I am not. I've read these cases. I've read the report. I worked the report. I helped edit I didn't write it. I helped edit the report. I think it's an exceptional piece of work, and I think the spirit of it is correct. I thank you for giving me my hour.
Well, good afternoon. First, let me say what a privilege it is for me to share this table with Judge Sessions.
Thank you.
I am a great admirer of him and the tremendous history of public service that he represents sitting here this afternoon. So it's a real honor to be here.
Thank you, sir.
For the past 4 years, I have represented 3 Guantanamo Bay detainees: a Saudi, a man from Tajikistan, and the last Russian in Guantanamo. The Saudi and the Tajik were released by the Bush administration, and I'm happy to report that they're back home with their families. They're living their lives peacefully. They're reclaiming lives that were shattered by years of harsh imprisonment, most of which at Guantanamo. The Saudi client, just to make an example, is now the mayor of his neighborhood in Dammam, Saudi Arabia, the eastern part of that country. He was married on the 1-year anniversary of his release from Guantanamo, and today he's got a young daughter who's almost 2 years old. We're in touch with him frequently by email, occasionally by telephone, but that's an example of someone who was locked up in Guantanamo and is now released and back about living his life. The United States previously released 7 other Russians back to Russia in 2004, but our client, Ravil Mingazov, was not released. And indeed, he continues to be locked up today, more than 8 years after his arrest in Pakistan in March of 2002. In mid-April, we tried the habeas corpus case for Ravil Mingazov in the United States District Court here in the District of Columbia in front of Judge Henry Kennedy. And I'm happy to see Allison LaFrac and Nathan Fennessy, who are part of our trial team, and others who couldn't be here. But we had that trial. And I will tell you that in 33 years of practicing law, I've never been involved in a case which at the same time was more rewarding, but also very frustrating in its dimensions. The frustration was not with the federal judges by any stretch. The frustration was with the length of time that it took for this case to actually come to trial, and the frustrations that are commonplace in trying to communicate with clients and the logistics of Guantanamo itself. Many people ask me how and why I decided to become involved in Guantanamo cases in the first place, and it might help you to know a little bit about my background. I grew up in a Marine Corps family. My dad was a career Marine officer. My mother was actually a Marine during World War II. So I really had it deep in the bones. My father was killed in Vietnam in 1966, and I had just started my freshman year of college at that time. And when I graduated, I went into the Marine Corps and was commissioned a second lieutenant. And I served 4 years in the Marine Corps as an infantry troop leader and a reconnaissance company commander. And I had a great experience in the Marine Corps, but after 4 years, I decided that I would get out. I went to law school, and I graduated from the University of Virginia in 1977. Since that time, I've been engaged in a civil practice in the District of Columbia. I joined the firm of Reed Smith, an international law firm with more than 1,500 lawyers, as a trial attorney in 1984, and I've been with them ever since. I and my firm, I believe, have always had a very strong sense of support for the legal profession's commitment to pro bono work. And as I saw the pictures come across the television of those early men who were brought to Guantanamo in their orange jumpsuits and their goggles, I thought to myself, if ever there was a group of people who needed pro bono legal help, it was these men. And frankly, with the help of my sister Suzanne, who's also here today and who is indeed a true national security law expert, I was introduced to a group called the Center for Constitutional Rights, which acts as a clearinghouse and helps to coordinate the Guantanamo habeas lawyers. And after 2 days of training with CCR, I took on the case for our 3 clients. I would pick up on what Judge Sessions said in terms of how these cases have unfolded using the experience that we had in our own case. The petition in our case was filed in 2005, and after several years of back and forth to the Supreme Court finally decided the Boumediene case, and in that case, habeas jurisdiction was clearly identified as being within the province of the U.S. District Court for the District of Columbia. And at that time, Chief Judge Lamberth of that court asked the former Chief Judge, Thomas Hogan, to coordinate the habeas cases that are all filed in that court in the District of Columbia. And so Judge Hogan, with input from the government lawyers and input from the habeas lawyers, fashioned a case management order, as judges are often called upon to do in connection with complex cases. This is not an unusual exercise at all for a judge. And the case management order dealt with the pleadings in the cases, what we call factual returns and traverses. The duty of the government to provide exculpatory evidence, discovery, how classified information would be treated, what the burden of proof would be, whether there would be presumptions in the case, how to deal with hearsay evidence, what would happen if a party decided to move for judgment on the record, something akin to summary judgment for those of you that are familiar with civil procedure, and how, in broad brush, evidentiary hearings might be conducted by the trial judges in front of whom these cases would ultimately be tried. So the case management order, along with a protective order that was put in place, again, with input from both sides, and that governed classified information and communications with clients, those devices became what I think is a fairly comprehensive set of guidelines for the preparation and ultimately the evidentiary hearings, the trial of the habeas cases. And while one might not agree with each decision and each component of the case management order or the protective order, it's my view that Judge Hogan did an excellent job in fashioning a framework within which these cases could be handled. To me, Judge Hogan in that context was a perfect example of judges doing what judges do all the time. Our case went to trial. We had our evidentiary hearing in mid-April of this year. And the trial lasted 3.5 days. Judge Kennedy heard us for 3.5 days. And during that 3.5 day period, I think that there were virtually no objections that were filed either by the petitioner, by our side, or by the respondents, by the government, with respect to the process itself, with respect to the standard